what happens when the drilling company or any company that's involved in activities related to that lease does not comply with the wishes of your lease. You're sitting there on your porch and you're drinking your iced tea, and you see that they're not following the lease. What do you do then?
You have to read the lease, but there's a stoppage. There's a stoppage to operations if they do not comply with our lease development.
How do you make them stop? And how do you make them stop?
And how do you make them stop? There's then we're all screwed. I just went, no. There's police, folks. There's lawyers.
It's not what happened in Texas.
Okay, that's all around. Thank you very much. Now we have Brian Conover, State Special Transit.
I feel a little different in the minority. I really don't have a problem with a farmer getting 2 to 3 times more for his hay. I really don't. I would love for our farmers to get more for their hay around here. I really don't have a problem with a homeowner who has been renting their home for very low amounts of money, welfare situations or whatever, to be able to get more for their rental. I also feel unique. Here's a person you've painted on the industry insider list, and then here we have an attorney, and here we have a pastor. What a unique combination up here today. My name is Brian Conover. I am a 17-year pastor at Calvary Baptist Church in Norwich, New York. My greatest role is that of husband and dad. I have 6 children, 5 girls. We finally had our boy 2 years ago. We have number 7, a boy, coming in August. And at the same time, we are working through an adoption of a 14-year-old Ukrainian orphan girl, and excited about that. If you stop by in July, sometime you'll see her. Come by anytime. The final and smallest hat I wear is that of the president of the Central New York Landowners Coalition. We're a group of 204,000 acres, primarily located here in Shenango County. These are unleased acres that have banded together to have a stronger lease of greater protections for landowners in this region. Our lease is about 39 pages long. The greatest amount of my coalition time lately is spent with farmers, widows, blue-collar folks from around here that are barely scraping by. I rub shoulders, listen to, and even pray with those from our community that are genuinely hurting and looking for some hope and opportunity. One thing I've learned in these last 4 years that we have come to agreement on today, and that is gas development is very complex. It involves architects, scientists, chemists, seismologists, hydrologists, etc., etc. But for us regular folks, I just want to present 3 considerations. That's all. 3 considerations that I believe can make this topic a little bit simpler for us, especially at the town level. Here's number 1. Consider the correlative rights of all town residents. The correlative rights of all town residents. There are 2 primary rights that are emphasized in the natural gas debate. Environmental protection rights. And this is a right that involves everybody. We all need to have quality of environment that we currently enjoy. Second right is private property rights of landowners. I submit to you today, confidently, that one does not need to be sacrificed for the other. The correlative rights of all town residents can be achieved. Environmental protection rights means that everyone has the right to the quality of environment that they currently enjoy. This is a right that both pro-gas and anti-gas people agree on. Pro-gas side championed this environmental protection long before this became a big issue in our region. It's the reason why our coalition started over 4 years ago. We could have leased 4 years ago, but chose to band together to make sure the greatest environmental protections were in place for our families and communities. The second right that I want to emphasize today that needs to be protected are private property rights. This has not been a part of the discussion in this room yet. Private property rights means landowners had legal, deeded, and constitutional rights to the full extent and value of their lands. Landowners bought their properties, managed their properties, we pay taxes on our properties, and we have as our own the full value of these properties, both surface and subsurface, and that is a matter of law, deed, and United States Constitution. I believe it's a caricature created to infer that those in favor of natural gas want to develop it at the expense of our water, air, and land. I do not want to do that. Landowners are the original environmentalists in this. We want to live here, drink our water, we want to farm here, we want our kids to get jobs here, stay here. I want to turn my property over to them when I pass. And we've demanded all along that our natural resources be protected. And we have complied with the state's current moratorium as they have worked for 4 years to try to figure this out. We are, however, the only side talking about property rights of those who own the property. This is not in the dialogue of those that are on the anti-gas side of things. The other side has never presented a provision to protect landowner, deeded, constitutional, and legal rights. It just hasn't come from them. There's no sympathy. There's no talk of compensation. There's no concern for the financial plight of hurting farmers, no respect for the deeded and constitutional rights of those who own and pay the taxes on their properties. And frankly, the conclusions of natural gas opponents would strip the legal and deeded rights of property owners in their pursuit of stopping this development, flat out. Our coalition stands firm by the rights of everyone in this process. We want the utmost in environmental protection, and we also must preserve landowner rights with no compromise to either. Our coalition stands for the rights of everyone. The course of our state stands for the rights of everyone, environmentally and private property rights. I believe the course of this town and this county should remain on track to provide for the rights of everyone, environmentally, but also with our legal, constitutional, deeded property rights. And I believe that's the course this town must maintain as well. So first is consider the correlated rights of all town residents. Secondly, value the state laws governing town land restrictions. There are state laws that govern town land restrictions. I'm not going to spend much time on this. This is the thing that bores the skull in my head. But here we go. There is the Environmental Conservation Law 23. The reality is the state holds the upper hand over towns in the development of oil, gas, and solution mining. Much has been done on the part of the opposition to muddy the clarity of this law. Interestingly enough, Ken and others, there's two documents that have come out that I am excited to submit to this town board at the next meeting. Number one is a memorandum on Environmental Conservation Law 23. This was written at the identical time the law was done, back in the 1980s. Let me read it for you. The provision for supersedure by the oil, gas, and solution mining law of local laws and ordinances clarifies the legislative intent. That's the big words. The legislative intent behind the enactment of the oil and gas law in 1963. The comprehensive scheme envisioned by this law and the technical expertise required to administer and enforce it necessitates that this authority be reserved to the state. Local governments' diverse attempts to regulate the oil, gas, and solution mining activities serve to hamper those who seek to develop these resources and threaten the efficient development of these resources with statewide repercussions. This is what we've talked about all along. With adequate staffing, that needs to happen, I understand. With adequate staffing and funding, the state's oil, gas, and solution mining regulatory program will be able to address the concerns of local governments and assure the efficient and safe development of these energy resources. That's the legislative intent that came out after Otsego County's developments on bans. It'll be interesting to see how that impacts the debate as these are being appealed and worked through an appeal process. Here's the other one. This came out this week. It's been there a long time. It's just have to blow the dust off the books. New York State Town Law 264 and 265. You may not have heard anything about this. This is brand new. Just this week, our committee surfaced these two laws that pertain to town land use restrictions. It's evident when you read through these two laws, the state desired to protect landowners, which, as Joe mentioned, are in the minority, and logically so, in any town. So the state desired to protect landowners from the unnecessary restrictions and land devaluing by non-landowners. These two laws state the arduous process the town must go through to notify all affected landowners in the town and even in bordering towns, lands that neighbor that town that is developing a potential ruling impacting their land use. Interestingly enough, each town with a ban so far in New York State has violated the process of these laws, most likely unknowingly, but they have not gone through the process of notification for all landowners and neighboring town landowners. It will be interesting to see how the courts look upon that. Here's another one. These laws also give right to those owning 20% of the lands affected, not 20% of residents. These laws say if there's a group of people that own 20% of the land in a town, they can protest land use laws. And then that protest requires a supermajority of votes of the town board, 75%, to pass any land restriction and not a mere majority vote. The climate is changing on town rule, and it's not a pure majority rule because automatically a landowner is in the minority, although they own and pay taxes and legally have the rights to their full properties. State law stacks the deck, saying if they've maintained the land, paid for the land, and paid taxes on the land, they can't readily lose their right to that because a majority of townspeople want to take their rights away. There's provision for that. This is a county map. It's almost done. You saw Joe's version of that of Portland County. Our coalition's been assembling this map. We still have the bottom third of it to complete, and there's a few thousand acres yet to fill in up over in this area. All the red are leased and unleased, or I'm sorry, leased and coalition acres in Shenango County. The green is state land. And when you know that the bottom of this map to be filled out, and it's no less red than what this upper midsection is going to be, there's an overwhelming majority of leased and coalition acres throughout the town of McDonough and also Shenango County. Just to state it plainly, I would count on any negative action of any town board in our county to be met with significant protest by landowners, which would then require a supermajority vote to enact any type of restriction on their land value and property rights. I also would guarantee that any ban or moratorium in any town in Shenango County would immediately transform this mass of landowners into a group enacting a class action lawsuit against that town for lost revenue for the uncompensated taking of their property rights. So the first two considerations, one is the correlative rights of everybody must be maintained. We can't just sacrifice one group for another and say forget about them. Everyone needs to be thought of. There are state laws governing town land restrictions, and they're just surfacing, and we're glad for them. The last thing, I just want to encourage us to defer to the experts at the DEC to fully study, comprehend, and regulate this activity. Every concern we've talked about has been sent to the DEC. If they received over 60,000 comments from this one comment period, everything we've talked about, they've heard about. They've probably heard hundreds or thousands of times. There's nothing that we've said that's going to be a surprise to them. We're dealing with an issue of such magnitude, both environmentally and financially, that we need the greatest scientific scrutiny to guide us. Not scare tactics, not hearsay, not governmental conspiracy theories, not forwarded emails, not Hollywood movie directors, and not quick Google searches. This requires legitimate empirical data. When the state DEC has devoted over 3 years and 11,000 hours in research, study, and documentation, why would a town want to hijack this issue and say we know more? And respectfully I say this, we have some very intelligent people in this room, much more intelligent than I. Nobody in this room has comprehensive expertise as the DEC. Nobody in this room has spent more money, more time than the DEC. We do not have town budgeted funds to hire hydrologists, scientists, seismologists, chemists, well architects, etc. to work for us on this. It doesn't make sense to reinvent the wheel when the state environmental regulatory body is and has been handling this for 3+ years. With full respect for the town board, I want to be plain. The clear reason why the anti-gas activists appeal to town boards is because they have lost their battle with the experts at the DEC. Why have the anti-gas activists lost their battle with the state? Because the DEC has done their homework on every claim of the antis. They have studied DIMIC. They've looked into the earthquakes. They've researched the claims of sick animals and nosebleeds and cancer. They aren't scared half to death because they know the facts to all the claims presented to us today. They have significant documentation to prove it, and we will be seeing that in the very near future. That is why people have now turned to pressure their town boards in advance of the DEC's release of their findings. That is why they do not have a plan to preserve the correlative rights of all in the town and merely trample over the rights of landowners for their agenda. That is why we need to end this bottomless pit of a time waster, allow the experts at the state level to settle this once for all. We need to give them every bit of information we have and look for an answer that solves this for all residents involved. The last paper that I'm going to give to the state, or I'm sorry, to the town, that I respectfully ask them to read, discuss, and pass without delay is a resolution. This resolution has been passed in numerous towns in New York's shale country, and it recognizes the DEC's 3+ year study on this issue and officially defers the town's actions regarding gas drilling to the final conclusions of our state's Department of Environmental Conservation. It only makes sense to consider the correlative rights of everyone in the town, to value the state's law regarding land restrictions, and to defer to the people who have spent the most money, time, and expertise on this, to comprehend and regulate natural gas activity. We purchased the Bliven Farm a year ago. We live up by Bowman Lake State Park. We have 130 acres here in McDonough. We love McDonough. I'm excited about raising my family here. We had our water tested 3 months ago. I should be getting the results back any day. I look forward to presenting them to the town board to see the level of quality of water and maintaining it in this area. I want to encourage and invite anyone who's not a part of the Central New York Landowners Coalition. Check out our website. I have my business cards up here. You may take one, stop by in July to see our future adopted girl and my family. Thank you for the opportunity to present. Any questions?
I guess I'll make it short. You obviously have a lot more faith in the DEC than I do. Yeah. Sure. And that's that. You know, we can disagree on that. But the one thing that interests me is the ability to strike the balance between private property rights and environmental rights seems to me a very difficult task, because what you do on your farm or what my neighbor does can obviously affect me. So and I don't want to go into a long discussion of it now, but what I'm wondering is you seem to be saying that you've addressed this balance in this 38-page, whatever your proposed contract is. Is that where you're addressing this?
What our lease is about is protecting the landowners and their neighbors specifically that would go through gas development. Right. It is an extremely comprehensive lease with greater setbacks, with greater landowner provisions. One thing that this shows you is, here's the well site in construction. There's never once a picture of what it looks like afterward. And I really think that's a misrepresentation of reality. Let's see the whole picture, beginning to end, not just here. Let's look at Walmart during construction, okay? And oh, we don't want that. Well, guess what? We don't mind it right now, do we? And it's settled down. So anyways, what this does, it talks about not only the well construction, how it's done, the setbacks. We talk about how we're finishing it, what type of grasses we want, how environmentally sensitive the reclamation of the site. We want it to look like it did before they came. That's what our lease is about.
Could I stop by and get a copy of your lease agreement?
You may come and look at it. I would be happy to show it to you at any time.
I mean, I said I don't want to spend a lot of time on it now, but I am curious how you achieve this.
You give me a call. You may stop by and look at it.
Okay, fine.
I would love that. Yep. Ken, go ahead.
Yeah, good. Like you, I share a belief in landowners' rights.
I just haven't seen it.
We should certainly respect landowners' rights.
How?
Well,
How?
do you want?
And we both.
I was speaking.
Yeah, sure. Go ahead, Ken.
Now, of course, we should not. I'm glad you have not dismissed non-landowners from the equation. After all of the, after 1830 or thereabouts, they were allowed to vote along with landowners. But I think it is a mistake to assume that all landowners, and I am one, are interested in pursuing gas drilling. So my question to you
I didn't assume that, Ken.
I didn't say you assumed that. Well,
Keep going.
you said the antis versus the landowners. I'm a landowner, and I guess you would characterize me or paint me as an anti, but frankly, I have an open mind, and I'm a mathematics professor and for many years, and I approach this more with my scientific background. I'm joined by the Scientific American that says we do not know enough yet to proceed, etc. So I understand we have differences on that. On the other hand, I hope we do find common ground on this issue of compulsory integration. The United States Supreme Court in 1943 said states have the right to compulsorily integrate, they called it pooling, because gas and oil flows. In New York State, there was a challenge to the compulsory integration in the 1980s. The appellate court upheld the right of New York State to pool and cited the 1943 United States Supreme Court because the gas flows. Now we know that the gas in the Marcellus and Utica does not flow. It flows only after the trespass. And therefore, I don't think you're on very good constitutional grounds unless you're suggesting that you do have a respect for landowners who do not want drilling under their property. I would hope that is your stance, since you're such a strong advocate of landowners' rights. Would you then argue that perhaps the drill should go around the property of those that do not want their land disturbed? And I think that as we move along in this very complex legal issues, we will revisit this thing. And again, the oil and the gas does not flow when it's locked into rock until after the trespass. And I think that's the nut of the legal argument.
I think,
but I'd like to look more.
That's not, I don't believe that that's the crux of the legal argument. The Environmental Conservation Law 23, if you look that up, it talks about the efficient and effective development of the energy resource in the state. Not as though there's a river of gas or oil underneath us. And so it talks about the best interest of the entire state. It also talks about individual landowners can impact negatively the development to the greater good of the state. That's what it's talking about.
You're quite right.
I'm not necessarily saying I like forced pooling.
I read the findings of the court in the United States, and there's a semicolon in that precise sentence. And it says, not only that, because we're all aware we don't want people drilling hundreds of wells all around there either.
Correct.
But semicolon, because the gas flows, they have a right to compulsorily integrate. This gas does not flow.
This doesn't. Others do.
Oh, sure.
But I don't believe that's the only determination in that factor. I'm not saying I like forced pooling.
They use the word and. When you use the word and, both have to be true. So for this to go, it's quite challenging. And I will point out that the legal case is beginning to be formed.
Mike.
Does this 39, 30, how many pages? 35?
39. I remember we finished it when I was 39.
I think that's going to be interesting to read it because it's a lot better than a lot of leases that people sign. I think it's a good thing that you guys are doing that. But what I'm concerned about is that the rights of a property owner are limited to such a degree that it's going to impact their neighbors or their neighbor's farm or their neighbor's house and the water. Here in McDonough, everybody is on the water. Everybody has a well within 65 and 200 feet. And what I'm concerned about, and others who own land and homes here who are invested in money, is how this fracking, if it's permitted in the town, in New York and in the town of McDonough, what's going to happen when people's wells start failing because of what's being done uphill from them on someone else's land. Will that lease agreement that you have, this is the question, will that lease agreement that you have or your land association is going to sign, going to provide provisions to help bail out your neighbor if their water gets ruined from the drilling on your land?
And just for the statement of honesty, there's a number of assumptions in your statement that not everyone holds to, but in that type of event, there are, and this was a large issue for us, we have provisions in there that hold industry and even other groups monitoring them to very specific standards, not just for us, but for everyone who potentially could be impacted by that. That all of those things are mitigated rapidly. We even have deadlines and all these types of different things invested in that document.
Yeah, but we know that you can't mitigate polluted groundwater. That's a fact. Once the water has been ruined by 400 chemicals and radiations, you can't mitigate it.
I don't know. There's so much discussion on this. Like, for instance, the Sautners down there, and Joe, you had a picture of their place up here in Dimmock, Pennsylvania. The EPA has come to them 4 times and has told them by empirical data and water testing that their water is safe and drinkable, and yet they deny it, and we continue to hear that. And we all know Dick Cheney's not in the White House anymore, you know? And we can't keep going back and saying there's this huge conspiracy. Even the EPA just recently came out with restrictions on fracking that was much less than what anyone anticipated from the Obama administration. So somehow these things have been somewhat mitigated if there was an issue. And it appears to be methane, which I'm telling you, I have methane in my water well right up the road here. Guaranteed. And I'm looking forward to finding those studies that come out that I just had done 3 months ago on this to understand the reality of it. But this remains to be seen, and I think everything is fracking. Trucking is fracking, methane is fracking, you know, the well site's fracking, and it's not. We need to really, you know, have specific definitions of things. Has frack fluid ended up in water wells? That's the big question. We know methane challenges have been there, and we know why they've been there. But we cannot equivocate and say one is the other. And that's where there needs to be clarity and definition. And that's why I believe there's been a greater level of scrutiny given to that by the DEC than really our discussions at a town level.
Could you tell me how much your test cost? Water test?
I was a part of a county-wide study through Cornell University of 105 water wells, 5 in each town of Shenango County. They are out in front of this. People here care about this. There are people not just complaining, there are people that are doing. And I applaud them for their proactivity on this. And I'm one of 5 in this region that had that done. And in speaking with individuals, there's believed to be a high percentage of wells that already have naturally occurring methane in water wells here in Shenango County. It's already here.
Will that be released when that comes back from all these people?
It's in the water right now.
The report, she's not talking about the methane. The methane's being released every day through our water well. But the reports, I'm gonna receive the report. I'm not sure how the overall report's going to be done for the whole county. I'm sure it's going to be released to the county. But When I receive mine, I'd be happy to let you know what's going on with that. I see a couple. Yes, ma'am.
I'm just curious to know, do you consider yourself and/or your agency to be neutral, pro-drilling, anti-drilling? Where do you put yourself on that spectrum?
Where we put ourselves is we believe that it can be done responsibly and safely with rigid oversight and safeguards. If it cannot be done that way, we're not going to have it done.
Okay.
We're not going to sacrifice our homes and land for this. However, we're not going to sacrifice our property rights. To speak plainly, there are a number of fanciful claims out there that truly are very frustrating when you've been at this for 4+ years. To see outdated studies, things that have already been disproven, to see those brought up as new proof that this is horrible, that even makes this, I have to say, it's enough to make a deacon cuss. Not a pastor, but a deacon. And so I'm not about to throw out my property rights because there's a lot of hysteria. No, I want facts on this. And that's where we are with it. Steve.
I'm also going to be like Steve did years ago when he had his well drill. I got a hard hat and I got a set of work boots. And I'll be on that property anytime that they're there. And that's part of what's going to be cleared in my lease.
Landowners are still going to be critical in the monitoring of this. I'm not going to sit back if they draw me and say, oh, I'll just whatever with the DEC. I'll grab an iced tea and a lawn chair and I'm going to be there. And I'm going to be looking at the inroads and I'm going to be checking out the well. And just as I've been down in Dimmock and I've been in Bradford County and I've been up and down the roads and I've been here in Shenango County on well sites. It's been fascinating, and I'm going to be there if they do it on me as well. I saw in the back. Yes, sir.
After hearing Joe Heath's presentation, and if the people that were asked to lease their land saw that presentation, how many leases would they have?
It's a great question.
I'll tell you how many. 0. It's the same thing when they want to put a radiation dump here in the McDonough area. You know what happened to this town? This town united. We marched on Albany.
We went to Albany.
And guess what?
So did I.
It's not here. And it's the same thing with this Joe Heath presentation. Como needs to see it. All the state government needs to see it. And then make a decision.
Based upon that presentation, with all respect to Joe, I saw him 2 years ago. That needs scrutiny. I appreciate what he's done. Obviously, there's no full presentation of what's going on. There is rebuttal to that, which we could order pizza at Biggs and just hang out for the whole rest of the day. But the reality is, I would still sign a lease because I've done 4 years of work and I do not agree with what came up on the screen over here. For the large part.
That got $30 for all the trouble. I mean,
is that the norm? That's your question. Is that the norm? Is that the way it should be?
That's an American citizen that got trauma.
It is not the norm.
I was in the service because I want to serve this country and the freedom of this country. And what you're talking about is stomping on my head.
I would love to talk to that woman. Number one, we need names. This needs to be understood. We can't just use anecdotal evidence to shut down landowner rights in which they genuinely have, legally deeded and constitutional. We need names. All of that information, I hope, went to the DEC, and I hope it went to the federal EPA, and I hope they're giving tremendous understanding to it. If it's true, then let's figure it out. If it's not, then let's throw it out. Is basically what I just said.
It's not the norm, but what would your living farm be worth if you couldn't drink the water? And my sister lives 50 miles north of here in Madison County, and to this day she cannot drink her water.
I would like to talk to her. If you could give me your information.
She can't talk to you because she took a settlement from the gas company that says she can't talk to anybody. The only way I know about it is because I'm family.
Well,
you should look it right up on Google. The well contaminations in Brookfield, New York, and they'll give you what what they gave Google.
It's really hard to talk about facts when there's no data, there's no names.
But you know, when
people need to come out with it. Did she sign a piece of paper?
Yes, and she got X amount of dollars. They came in and they put a big filtration system in her cellar and told her, you can use it to cook with, you can use it to do your laundry with, you cannot drink it. And here's a check for, I don't have any idea how much, she wouldn't tell us. And you can't talk to the press, you can't talk to the news, you can't talk to your neighbor.
You know, I've heard those types of things. The Saunders didn't take any type of a settlement down in Dimmock, and the EPA's come back with data on them, and they're not willing to accept it. So, you know, there's a lot of different things. That's why you have your story, I have my story, others have their story. There needs to be an outside organization that takes all of these things, synthesizes them, and comes out with something that protects the correlative rights of everybody. And whether we like it or not, that is the DEC. They also look at farming. They also look at pesticides. They also look at what goes on the roads. And the reality is, whether you like it or not, if your neighboring farm spreads pesticides or kills the grass or do whatever, they're the organization to deal with, and it's not in our...
It's not the norm, but I don't want them drilling near me because I value my well. Without my well, my land is worthless.
That's fine. And if it was done appropriately with proper oversight restrictions, I would let them on my property.
Yeah, but you can't guarantee that they're going to not say, oh my gosh, we just contaminated the well. It's not the norm, but it could happen.
And you go ahead and bring me one industry where there are guarantees and no risks, and we'll go with that.
Okay, right.
Go ahead, ma'am.
I just was wondering, since we talked earlier, people asked about getting released out of what they signed. Do you allow folks to kind of back out once they...
There's no obligation with us. If we
once they're in, like people asked earlier, if they've already signed something, can they get out? If people already did that with you, can they get out?
Yeah, we're not a leasing company. We're a landowner advocate.
But the lease that you have them in, or that your group is in, or however it works.
Yeah. So what it is, we have a group of landowners. We have a 39-page lease, and we're going to go to different companies through our attorneys and begin to talk about and negotiate this together. And when we hit a final offer and the company says we're going to give you X amount of money to be able to do this with your restrictions, then we go back to our constituents. If they do not want to sign with a company, they don't need to. They can remain unleased, they can do absolutely nothing, and there's absolutely no obligation.
Brian, what she's asking, if she signed the lease,
If
can she back out?
people, like this lady asked earlier about somebody signing a lease, and all the, Joe here told us how there's so many ins and outs. So if people are in your grouping, can they revoke or whatever, get themselves out of that?
Once people have signed with an industry, chances are that lease is irrevocable during the term of the lease. Really, that there's no legal way to get them out.
I think what he's saying, maybe just clear, is that if a gas company said, "We'll sign your lease," they would go back to the people in their group and they would say, "All right, now here's the deal. You can sign or not sign this." Those who did sign, like any other legal agreement, would be legally obligated.
Okay. So
Yes.
Those who did not sign could walk away.
So your group
Stated better than myself.
Okay, so just to clarify again, your group does not make that decision for those people. It just...
We negotiate it. If they want it, great. If they don't, walk away. You don't owe a penny. There's no obligation.
Okay, this is not as meant as a criticism so much, but how long have you been trying to sell this lease to gas companies that had any gas companies signed it yet? I mean, it sounds like a great lease, but on the other hand, if you can't sell it to a company, you know what I mean? It's not going to work.
There are some things I can't say, but we have had offers for our coalition in Shenango County specifically.
But
with our lease,
with your lease
protections.
Okay.
Yes. And the biggest detriment to getting a lease in New York State is not our lease. it is New York State. Okay. Our holdup right now is not our lease, and it's not our acreage and formation. Our holdup right now is this 4-year-long moratorium in the state. I mean, it's a sizable risk for them to come in, not knowing if or when or whatever this will be available.
Sure.
Yep.
Anybody else got some questions?
In the back.
What do you do when your 39-page lease with all those words on the pages and at the end is your signature? What do you do when that lease is not complied with by the people who, you gave the lease to?
If they go outside of the demands of that lease,
they don't follow the stipulations, the wording of your lease on those 39 pages with all those protections. What happens when the drilling company or any company that's involved in activities related to that lease does not comply with the wishes of your lease? You're sitting there on your porch and you're drinking your iced tea, and you see that they're not following the lease. What do you do then?
you have to read the lease. But there's a stoppage. There's a stoppage to operations if they do not comply with our lease development.
And how do you make them stop?
And how do you make them stop? There's then we're all screwed. I just what? No, there's police, folks. There's lawyers. There's police. There are courts. There's the DEC. And the problem here is the only people that we trust is ourselves. And there are outside organizations and groups that have the power of the law, and this is a legal document, that we can go ahead and enact litigation against these people for stepping outside.
And you're going to take this industry to court.
Sure, happens every day.
Thank you all for coming.
Can I say something before everybody goes? I want to thank the board for hosting this meeting and the speakers for coming. I think when we created this, we just had a lot of good information.